A man in El Paso, Texas, whose identity we are concealing, is under a criminal charge in New Mexico. A charge he says is completely unfounded and totally ludicrous.
This whole thing is crazy. I'm charged with something I didn't do at all. I know everyone that's accused of a crime says they're innocent, but I'm charged with a crime that didn't happen at all. You can check for yourself. These people are nothing but dirty.
We did look and discovered there are many questions that need to be answered. First, what is the actual charge? The indictment shows a charge of aggravated stalking, but the New Mexico statute shows 4 separate subsections. Section 1 reads: a person who knowingly violates a permanent or temporary order of protection issued by a court, except that mutual violations of such orders may constitute a defense to aggravated stalking. Section 2 reads: a person in violation of a court order setting conditions of release and bond. Section 3 reads: when the person is in possession of a deadly weapon. Finally, Section 4 reads: when the victim is less than 16 years of age. While that phrasing is contained in the indictment, the specific statute isn't listed. However, the court records show he is charged with violating Section 2. Violating a court order.
It's really amazing. How can I possibly violate something that didn't exist? It's just stupid. That's like a cop giving a speeding ticket for going faster than the speed of light. So I get arrested for violating what? The space-time continuum?
The records clearly show he was arrested under this charge, and yet, the records also show that no events existed before his arrest. Thus, no court order existed. Could this be a typographical error?
A typo? If they say it's a typo, then they have to explain why the officer and the prosecutor both lied to the court. They can't explain away lying as a typographical error.
He is referring to the grand jury proceeding and his district court arraignment. In the grand jury, the officer was asked about a restraining order. This is that transaction.
Have either a tenant or parents attempted to get a restraining order on a
Yes, they have.
And that restraining order has not obviously resulted in him stopping from attempting to contact her, is that right?
That's correct.
Then at his arraignment, the assistant district attorney makes the following statement.
He has continually gone to her games and videotaped them, even though he has been told repeatedly to stay away, even though there is an order of protection out there.
And then when challenged, the following occurs.
Maybe the child's parents sought a temporary restraining order at some point, but nobody ever communicated.
Do we have an order of protection? I apologize, Your Honor. I thought there was one. The parents tell me that it was denied. They did petition the court, but the court denied it.
In the grand jury, the officer lied by saying or implying that I violated a restraining order. Then at my arraignment, when the ADA makes his accusation, he says, I thought there was one. That's funny. I thought perjury was a crime.
In New Mexico, perjury is a crime. The statute reads, perjury consists of making a false statement under oath, affirmation, or penalty of perjury, material to the issue or matter involved in the course of any judicial, administrative, legislative, or other official proceeding or matter, knowing such statement to be untrue. Do you believe the officer committed perjury?
Oh, hell yeah. Not only did he lie about the restraining, he lied in the fact that he's telling the grand jury that he investigated this supposed crime. Which he obviously didn't, because if he did, he wouldn't be lying about a restraining order. Come on, if these people told him there was a restraining order and he didn't check to see if one existed, I mean, he is in law enforcement. How hard is it for him to check court records, police records, something? How could he not know? At the arraignment, the ADA clearly says, I thought there was one. Just flat out proof that no one checked these people's stories at all.
Was there an investigation? Prior to his arrest and indictment, the Attorney General of New Mexico released an extensive guideline towards the investigation of stalking cases. If the officer was aware of this document, then he somehow overlooked several key elements. One that we think is crucial is an actual interview or questioning of the suspect. Did the officer interview or question him before the indictment? According to the records, no interview occurred. The police reports do not show any interview.
Granted, I know those TV shows are fiction, but even in real life, they interview or question suspects before formal charges are made. Not me. I wasn't even given the right to talk to an attorney before I was indicted. Nobody asked if I had an alibi, if I had any reasons or excuses, nothing. So New Mexico is only one side to any story, the prosecutors.
The officer himself did not talk to him until after he was indicted, as shown by this document. So did the officer investigate the alleged event or events? According to the guidelines, and even standard criminal investigation procedures, officers question witnesses to gather as much information on the alleged event. The more witnesses that tell the same story, gives the officers a better description of the suspect, and a more accurate detail of the suspect's conduct or activity. Yet in this man's case, there are no witnesses to the alleged event or events. In the few police reports, not one has any comment from a witness, impartial or otherwise. More so, in the one event that may have led to his arrest, not only are there no witness statements, there's not one statement from the alleged victim. Even more questionable, he is charged with stalking, for attending athletic events where individuals, teams compete. Led by coaches, officiated by referees, watched by fans, parents, classmates, friends. In other words, out of these events, how can there not be one witness?
That's easy. I didn't go to all them games.